So friends, let's take a vote in this course. And I think it is for me as well as for you. And the vote statement says something like this. The views, thoughts and opinions expressed in this lecture belong solely to the author, that's me, and not necessarily to the author's employer, organization, committee or other group or individual. We assume no responsibility. That means we means this course assumes no responsibility or liability for any errors or omissions in the content of this course. You cannot sue us. The information contained in this presentation is provided on an as-is basis condition. So I give you no guarantee of what the course content is. Either of the completeness of the topics to be covered, or the accuracy of the information that is shared, or the usefulness or timeliness of this information for you. This is my oath, friends, for this course. I hope you have read this and you have agreed to take this course. Thank you. Friends, this is a standard disclaimer in most contracts. So wherever you make contracts, the one who provides you the product or the service comes up with such kind of disclaimers in which the service provider or the product manufacturer clearly says that we assume no responsibility or no liability for any kind of fault, defect, errors, omissions, shortcomings. They simply make a very tall statement which many customers, consumers, citizens have already agreed to. And this becomes their defense in court, saying, look, the customer or the consumer has already agreed to this contract, we already told him the disclaimer, and hence we are not responsible. Right? Now, why do people get into such a habit is because, please note, in any kind of contract, the market conditions play a very critical role. Now, please note, in market condition, I mean that many of these service providers or these manufacturers or these producers are in a position of dominance. And the position of dominance is they have a higher bargain. Now, why there is a higher bargain? Because there is, a disparity between the demand of the market and the supply of the market. So wherever demand increases and the supply is in short, the supplier has a higher bargaining capacity and the supplier or the producer dominates contractual terms and conditions. So he creates this clause. Why? Because he has the power to draft the contract. He has the power to put across the terms and conditions of the contract. And he clearly then says, look, I will hold no responsibility or no liability. I think what this slide probably tells you is, in contract law, what is the legal validity of such disclaimer clauses? Are these disclaimer clauses valid and enforceable? If they are valid and enforceable, please note it down, the seller can escape liability or responsibility. Are they entirely invalid? If they are entirely invalid, the citizens and the consumers get to protect their rights in contract. But to what extent? And how are consumer rights to be defined? Are they defined under the consumer protection law? Can they be also brought about in contract law? Because please note it down, in many cases, you may enter into a contract, but not necessarily as a consumer. So I think it's important at this context to understand that the importance of modern day contract probably comes across from such kinds of one-sided, arbitrary, unfair clauses and terms and conditions in a contract, which you would probably see in your everyday life. Right? For example, you go to a cinema theater. First of all, I have to ask you, where do you see the terms and conditions of you trying to see a movie in a cinema theater? Anyway, that probably we later at some point of time. But most often than not, the cinema theater owner will say, look, I assume no responsibility or liability for the content of the film. Or if the film closes or forecloses a little bit early. So all of these are standard clauses. They're there in the market. We have to test and evaluate whether these clauses are valid, whether such kinds of contract are permissible or not, because you will notice that if such kind of contracts or clauses are allowed in a legal system, obviously it will result in exploitation, it will result in market trying to make profits from the vulnerable sections of the community, and that is probably the reason why there is a need for contract law to understand, evaluate, moderate, and determine the rights and obligations of the parties to a contract. Going further, friends, let's understand why should we study contract law. What is the importance, and what will give you contract law study too. Friends, interestingly, please note, contract law is a law that attracts human behavior. Yes, it does. When I said human behavior, I am talking of the behavior of the seller as against also the behavior of the buyer. You will notice that when law basically is called upon, law actually regulates discipline. Law regulates human behavior in one sense, because if you do not regulate human behavior, the human behavior can be that of a social animal. He can get exploitative, he can actually get dominating, and people will feel that law and legal system does not exist. So I think to bring peace and order in a society, law is required. Now, to bring peace and order in commercial transaction, in market transaction, in economy, in businesses, contract law is very, very important. And what does this law set across? I think please note, when the legislature brings any law, now please note it was the Britishers who brought the contract law, but you will have the legislature actually having the power to make law. When the legislature sets out a contract law, they expect a certain kind of behavior. The certain kind of behavior is expected from the parties in the contract. For example, when we talk about special contracts, we may be talking about bailment, pledge, indemnity, guarantee, and agency. These are special kinds of contracts. Sale of goods is also a special kind of contract. So what does the legislature prescribe in the law? They prescribe what should these parties to the contract do. For example, in bailment, we say what should the bailer do and what should the bailee do. The interesting concept, friends, is the law sets out the rights of the parties. Now, for example, rights of the bailer, interestingly, will become the duties of the bailer. So the contracting parties can make a contract. They have the freedom. No problem, no challenge regarding the same, but that freedom is not an absolute freedom. The law will actually set out the societal norms for those kinds of freedom to come as well. Continuing on our discussion on why should we study contract law, you will notice that there are certain theories which have said that there's actually no need for law in contracts. Rather, you would notice that there cannot be a law for every kind of contract. Now, when I say every kind or type of contract, what does this mean? You will notice, friends, that, when I say a cab service driver is taking you from destination A to destination B, can you have a separate law? Can you say that because a company is hiring an employer, can you have one law just for that? If suppose, you come across market buying and selling of different products, can you have separate law for each of these contracts? So you cannot have specialized contract law, but you can have a general contract law. The reason being, because see, frankly, when we say there is freedom of contract, there is a theory called the freedom of contract theory. It says that the parties must be free to enter into any kind of contract. This must be let go in a society, because that must be something that everyone should have a choice of. And this will encourage freedom of choice, freedom of business, and it's one of the essential freedoms that every democratic country would want to nurture and actually develop. And hence, freedom of contract is actually very important. Who do you want to contract with? That's the first freedom. What do you want to contract with is absolutely the second freedom. However, when you have freedoms, you will notice that even in the Constitution, you have certain reasonable restrictions. Right? No freedom is absolute, and hence, the freedom of contract also cannot be absolute. While you must have the freedom to choose who you want to contract with and what you want to contract, there ought to be some kind of a law or regulation that is necessitated by saying, okay, look, you can't probably hire someone to cause damage to a third party. We say this is called a supagi contract. You can't hire someone to actually, do some contract killing or say kidnapping, right? We'll have to have certain public order in place about which contracts can be permitted and which kind of contracts cannot be permitted. And hence, while you basically have that freedom, there are some reasonable restrictions which are justified by public order. Right? Secondly, you also notice that while you should have this freedom, the freedoms often get abused or exploited by a few individuals who probably think that this is something that they can actually do. So freedoms have to be regulated in good faith. And hence you will notice that it's very important that when parties choose each other or try to trade or contract with each other, they must do so in good faith. And that's one of the principles in contract, that parties must exercise good faith. They must, what does good faith mean? It is just saying there should not be any malified intention, there should not be any bad motive, and people must actually contract. And please note, why do people contract? Because I think people want to have a win-win situation. Both the parties must benefit, right? And hence contract must promote that win-win situation, and for which I think some curtailment of the freedom of contract through law or through contract law is probably one of the justified reasons. One more thing that you will always notice about why we should have a contract law is because very often than not, you can actually make an agreement in which you say, I do not want to make it enforceable. Right? Parties can actually make agreements which are not enforceable at all. They just want to make a social agreement or what we call a social contract. Right? There may be so many such relationships that may resemble like contract but should not be treated as contract. And that is where probably the law will try to intervene. Law will try to set down certain regulations, certain guidelines, certain essentials, and then say which contracts have to be enforced and which contracts can be left outside, because it is just an arrangement or some kind of a relationship between the parties, and it is best left to maybe some other legislation to regulate and govern, or left to the freedom of choice of the parties as well. Right? So interestingly, you will also notice that this kind of a freedom theory that is important, the contract law actually does not say that this freedom is not available. They say you have still the freedom, right? But the freedom should be in such a place where you can negotiate the terms of the contract in a trust relationship, in a good faith relationship. You can form the contract in a fair basis, and that will properly promote the parties, that will promote the legal system to be an orderly legal system following rules and regulations of law. And this way, I think every person's right in business and in contract and in commercial transaction can be protected. This is probably also one of the reasons why study of contract law becomes very, very important. Third, friends, contract law originates from the laws of obligation. Right? And when we say law of obligation, friends, please understand, it is the law of duty more than the law on rights. Please note, obligations are always there in a society. Every society, right? An organized society, be it a village, be it a town, be it a state, be it a country, every such kind of society is an organized society. And in organized societies, people must owe obligation to each other. This is the duty that you have. What is my obligation? My obligation is probably not to misrepresent when I enter into a contract. My obligation is to show good faith while entering into a contract. My obligation is not to hide any vital information in this contract. And please note, friends, societies flourish when these obligations are respected and honored by the parties. Right? And hence, you notice one of the easiest definitions of contract is that contract is called the law on promises. Yes, it is the law on promises. What is promises? Maybe the seller promises to sell his house and the buyer promises to buy the house. This is the law on promises. And promise, friends, when I make one, say between the seller and the buyer, I actually owe an obligation of fulfilling that promise. So you can't make promise without having no intention of fulfilling the same. So once I make a statement, once I make a promise, once I say that this is what I want to do in a contract, it is the duty of the law to ensure that the obligation is completed. So if the seller makes a promise to sell his house, he has undertaken the obligation to deliver the house to the buyer. And the law of contract tries to fulfill and enforce that obligation which the seller has undertaken towards his buyer. Now, if please note, this kind of obligations in a society, please note, they are not social obligations. They are commercial obligations. They are legal obligations. Social obligations, the law still probably need not intervene. But a legal obligation, when you make a promise to someone else, The law must actually value that legal obligation, must treat it in a way that the rights and duties and obligations between the parties are actually ensured. Just imagine if contract law was not there in these circumstances, where the seller has made a promise to sell his house. What will happen? The rights of the buyer may be adversely affected by the seller. The seller may make these promises to two or more persons, and the buyer then, who has probably paid an advance, who is expecting that house to be delivered to him, who actually has invested all his saving to buy the house, his rights will be infringed, and he would have no way for the legal system to redress his grievance. And hence, the seller ought to have obligation to sell the house, and the buyer ought to have obligation to make the payment towards buying the house. These are obligations that parties to a contract usually have. And these are obligations that the law tries to enforce. It tries to fix. And it tries to state who should do what in contract. And if suppose one fails to do it, what is the kind of liability that the law would want to impose? Because remember, friends, when obligations are breached or broken, there ought to be liability that will bring about an effective legal system and an orderly society in any given country. However, you must also understand, friends, that obligations are of two kinds, to be honest. One obligation is something that you can take on your own. We call this self-imposed obligation. There are certain obligations which are externally imposed. Right? What is an externally imposed obligation? It could be something that a public law puts on a party. For example, the law that prohibits smoking in public places may say, don't smoke in public place. If you do so, there is a penalty. This obligation not to smoke in a public place is an externally imposed obligation. Right? It's a public law domain. There may be policing regarding the same, there may be punishment or fine regarding the same. And hence, yes, for the betterment of the society, for betterment of orderly behavior among all citizens, public obligations are very, very critical and important. But please note, the obligations in contract law are not imposed by somebody else. The obligations in contract law are self-imposed. If you wish to take a contract, if you wish to enter into a contract, you actually undertake the obligation yourself. It's a choice that you have. It's a freedom that you have. If you don't wish to sell your house, don't sell it. Right? If you don't wish to buy, you don't buy it. Nobody is going to force you to do so. Contract law does not actually insist upon that. Right? Unless there are certain instances where the courts may probably force you to do it because you have breached the law, you have breached the obligation. The court may actually do it. But initially when the contract is made, you have the complete freedom to either take the obligation, one, to determine the extent of the obligation, and this is something that parties can actually exercise. And that's why very often contract law is also called a domain of private law. It is private obligations, but with public policy and public perception, and contract law actually takes you forward. And this study makes that relationship all that very interesting. Also, you will notice that the purpose of contract law, if we would just want to state it in terms of how the study takes you, is to actually categorize a fair contract. But to be honest, the law also tries to bring in an attitudinal and behavioral change in the parties, to actually start and say that fair contract is fair business and fair business is fair behavior. So fairness in contract is an aim that contract law attempts to achieve. Right? You ought to be fair to the party. It's not about the law does not say you can't make profits. You can, but there must be a fair profit. You can't make it at the expense of someone else, right? And hence, any term in a contract, any procedure in a contract should be so fair so that it actually is rendering justice to both the parties and it looks fair to both the parties. Finally, you will notice, friends, the theory of collective bargaining. Contract law actually is probably something that you can say comes from the theory of bargaining, which is also used in labor law in terms of collective bargaining. The fact is, when you say collective bargaining, friends, you will notice legislations like Competition Act, consumer law, they actually promote the spirit of collective bargaining of the consumer. Right? It strengthens consumer rights, consumer movement. It strengthens consumers' ability to actually look at their rights, which are not going to be suppressed by the other party. And look, this is no longer a seller's market, it looks to be a buyer's market. Right? So when it's a buyer's market, I think the buyers ought to seek protection, they ought to seek their redressal of grievances, their rights need to be protected. And hence, the study of contract law in that sense, furthers the spirit of collective bargaining, more so in employment. Now, if you look at employment and collective bargaining, friends, you will notice that it was employers who were exploiting the employees at this first stage, right? During the industrial revolution and during the first issues of independence. Why? Simply because there was a mismatch of demand and supply. The demand for jobs were so much and the supply of market was so short that the employers started exploiting, and hence they actually had a lot of unfair terms in contract. They had unfair policies towards their workers in the contract. And hence, the spirit of collective bargaining meant that when the laborers formed a union together, they could actually negotiate better wages. They could actually negotiate better work conditions. They could actually negotiate better pay. Right? So it's important that when markets get exploitative, people must come together. And the contract law actually facilitates that kind of collective spirit in terms of ensuring fair bargain between both the parties. Now let's move on to understanding historical background. So the Indian Contract Act 1872. It's important for us to contextualize this law as something that was felt need of the colonial rule in India. And while contracts existed in India, I'm sure one would understand that it existed when every kind of market economy was in place. But before 1872, friends, you will notice that there were two dominating rules in the Indian society. One rule dominated the Hindus under Hindu law, the other rule dominated the Muslims as Muslim or Mohammedan law. Now, both Hindu law and Muslim law were religious codes and religious principles that governed human behavior in a given society. And hence, being a law that applies to a religious community, please note the Hindu law and the Mohammedan law did actually lay down certain obligations for contract. There are certain principles of contract that actually derive its basis from customary practices and customary law or usage. And many of these customary usages and practices are imbibed in religious and personal laws. So, probably the Britishers, when they came and ruled in India, please note they realized that the Hindus were probably practicing Hindu law in contracts. The Muslims were adopting Muslim law in their contracts. And when a Hindu-Muslim probably makes a contract, we are not sure which law should actually apply. And should there be a law in the first place or not? Then we had the Britishers. We had other different, people who came to India, the Portuguese, the French. They came to India and basically they came to India for what? They came here for trading. And, this was a great country. The spice route is something that we all very well know. And now to exploit that trading, to exploit resources in this country, I think the Britishers really realized that they had to bring in rules, right? They had to bring in rules of trade. And they had to say that, look, for the entire country, we must have one law. And probably if you look at the drafting of the Indian Contract Act, it was the Third Law Commission that drafted the Indian Contract Act. If one would want to look into the history, it was the first law commission that contributed in drafting the Indian Penal Code 1860. And by the year 1872, the Third Law Commission was present and they drafted this Indian Contract Act 1872. It was supposed to be a uniform contractual code for the entire country, and this governed contractual relations from now on. So this had to be applied to the entire territory of this country. And that's how the whole aspect of the background of this legislation becomes very, very critical at this point of time. Now, interesting part of the 1872 law is, please note, while the Act has come into place, at that point of time, there is no requirement for rules to be brought into force. And even after independence, friends, if you just want to notice, the Indian Contract Act is a substantive law. It's a law on obligations. It's a law on definitions. It is the law on what is valid, what is void. It is something that defines the various obligations in law. But it does not anywhere state the procedural aspects of contract law. And interestingly, friends, even after independence, even as we speak today, it is one of those substantive laws which does not have a procedural law. So there is no contract act rules as we speak in the Indian contract.